Good morning, everyone. Welcome to Assembly Judiciary. Welcome to those here in Carson City, as well as anyone down in Las Vegas, and those viewing online today. Committee secretaries, will you please take the roll?
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadim, Orentlicker, Roth, Urick, and Chair Miller.
Here. And with that, just a few friendly reminders. One, please make sure that you turn down all of your electrical devices as to not be disruptive during the meeting. Also, that we will have public comment at the end of today's, at the end of today's meeting. There is an agenda that's posted on Nellis, and on that agenda, you can find the phone number as well as the meeting ID, which is today 889-6320-9568. That is the meeting ID, and that is for anyone choosing to testify or make public comment over the phones today. For all presenters, we ask that you keep your presentations to 15 minutes. And for anyone speaking either in testimony or public comment, we ask that you keep your comments to 2 minutes. All speakers, we also ask that you state your name, and the first time you state your name, that you please spell it so that we have it correct for the record. And with that, we will go ahead and begin. Our first bill today is Assembly Bill 141. It revises provisions related to the Judicial Department of the state government. So with that, I will go ahead and officially open up the hearing. Assembly member, do you have any co-presenters or anything with you?
No, ma'am, I don't.
Okay, well then please just introduce yourself, and then whenever you're ready, please proceed.
Great. Thank you so much. Good morning. My name is Yu Wing, and I have the honor of representing the Assembly District 8 in Southwest Las Vegas. Even though this is my second term, I'm still very nervous. So if I start speaking in Vietnamese, please apologize and correct me, and I'll go back to English. So let me restart on that introduction. Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Committee on Judiciary. I'm here today to present Assembly Bill 141, which revises provisions relating to the Commission on Judicial Discipline deliberative session minutes and introduces a trial experience requirement for candidates for district judge in Nevada. As members of this committee may be aware, the Commission on Judicial Discipline play a crucial role in maintaining the integrity and accountability of our judicial system. The Commission has exclusive jurisdiction over public censure, removal, involuntary retirement, and other discipline of judges. To that end, transparency and public trust in this process is important. As a whole, AB 141 addresses two key aspects of our judicial system. One, the deliberative sessions of the Commission, and two, the qualification for district judges. By making key information more accessible to the public and ensuring district judges possess practical trial experience, this bill aims to strengthen public confidence in the judiciary and enhance the quality of justice in our state. Section 1 of the bill requires that any minutes of the Commission on Judicial Discipline's proceeding be made accessible to the public while maintaining the privacy of the deliberative sessions themselves. This approach strikes a balance between protecting the privacy of the Commission's internal deliberations and ensuring transparency in its decision-making process. Concurrent to other hearings that are made accessible to the public, deliberate sessions should be held to the same standard. Judges, no matter where in the country or at whatever level, hold positions of significant authority and power. Like Spider-Man, with that power comes great responsibility. Responsibility to act with integrity, responsibility to act with fairness, and being responsible for their actions. When a judge faces charges, the public should be entitled to understand the decision regarding their conduct. In making deliberations publicly accessible, we, the public, are provided clarity into how their action and decisions are based on fairness and not secrecy. Moreover, the judicial process, in whatever capacity, should be fair. In knowing why judges have been charged, the public knows who they are voting for, including their history. On Section 2, amends the qualification for district judges to add requirements for candidates wishing to seek the coveted district judge office. With your permission, Chair, I have submitted a proposed conceptual amendment that clarifies some concern that I have heard from stakeholders.
I'm sorry, and is the amendment posted, or when did you submit it?
I apologize, Chair Miller, Yui Win for the record. I sent it to all the members before the meeting and made copies available for the public right now.
Okay, so it's not posted yet. Okay, thank you.
Correct. With the proposed amendment in Section 2(1)D, I removed trial from trial counsel, leaving only counsel, as well as expanding on the capacity in which one would provide counsel in at least 10 trials or arbitration in any court of forum in this state. Recognizing that leaving trial counsel might limit the pool of candidates, simply leaving counsel is intended to cover trials that happen in corporate law through arbitration and require material participation by the counsel. Often, lawyers are listed on court pleadings but have little involvement in a case. I believe this change would make the provision more practical, while still ensuring that candidates have sufficient experience for the seat that they are running for. Section 4 clarified that the additional qualification prescribed in Section 2 do not affect the current term of office of any district judge who is serving in that office as of October 1st, 2025. With that, that's the end of my presentation. So I would welcome any questions.
Okay, Assembly Member, we're going to pause for a moment because members do not have the email. It wasn't sent to members. So is there any members that have the amendment? Do you have paper copies?
Yes, I have it.
Okay, so if there's anyone that needs to, please raise your hand if you need a paper copy of the amendment. Okay, we'll get them over here. Oh, I did not mean for her to have to leave. I thought there were paper copies over there. Are they all taken? They're all taken. Okay, they're all taken. Okay, so please just give us a moment. But members, if you want to queue in for questions. Okay, thank you. While you all are having a moment to go over that, we will begin questions from Assembly Member Ornlicker.
Thank you, Chair, and thank you for your presentation. I want to ask about the experience. I appreciate the desire to ensure there's experience. So 2 questions. One is how you settled on the number 10 and why you could have somebody who's been in 50 trials in another state, moves to Nevada, and would not qualify under this, and that seems odd. If the goal is to have trial experience, it seems like it would be not that different whether it's Nevada or Utah or other states.
Yui Win for the record, through you, Chair, through the Assembly Member.
Please go direct.
Thank you. Ewing again for the record, and I think the numbers were decided just upon working with stakeholders, but we are willing to work on that number if there's a number that will be more sufficient. We definitely, again, don't want to put more restriction and have qualified candidate running for these offices. But we do want to set a bar so that we can have the ability to have qualified folks who have the trial experience needed so that on day one after they got elected, they will be successful in their role. So that number is there as, the stakeholders coming up and thought that would be a good number, but we can also work on that number if you feel that there needs to be changes to it.
Thank you. And on that they have to be in this state as opposed to a neighboring state, 50 trials in another state, you come here, you can't run for, even if you meet the other requirements about being a member of the bar.
Yui Wen for the record. Thank you again for that. I think we want to make sure that folks understand what Nevada process is. And of course, we want folks to be familiar with Nevada laws and how things work in Nevada, because I know that all of our states have different ways of doing things. And we definitely want folks who have been here in their community, who have, know what the community is like before they make decisions that would impact our community. So I would welcome amendments or suggestion on how we can make that better. But we do want people and qualified candidates who are familiar with Nevada laws to be presiding over Nevada courts.
Thank you so much. Our next question is from Assemblymember Hardy.
Thank you, Chair. Good morning. I just want to follow up on what my colleague brought up. I too think, we want experienced people presiding over trials and courtrooms and such. So I was just curious how you came up with this bill. Like, is it from complaints of judges, or there are a lot of appeals or overturns and such like? So I just wondered how you came up with the bill. Thank you.
Yui Wing for the record. Thank you, Assemblymember Hardy, for the question. I think overall, in general, many constituents came to me with this issue and asked that I look not just into this role, but several other roles in our state in terms of qualifications to run. I think most of their concerns are around when there comes to judicial election. There were maybe, sometimes 60, 80 names on the ballots, and there is minimal information, even though they can go on websites, they can go on, the candidates' materials that they may get in the mail, but there isn't a way for them to see that there is qualifications that would make the process more fair for the member of the public. So these are the concerns that were brought up by my constituents, and I want to make sure that I address and listen to the constituent that we all serve.
Thank you so much. Our next question is from Assembly Member Roth.
Thank you, Chair, and thank you so much for the presentation. I guess just kind of conceptually, thinking about what kind of experience really makes a good judge. I do reach that threshold of having done 10 jury trials, but I actually think now that I practice appellate work, that experience gives me better qualifications. And so I'm wondering if there can be a bigger conversation about, I see you've included arbitration, but reaching that 10 threshold is very hard for a lot of attorneys, especially who practice in civil law, because you just go to trial a lot less. And you could have less than 10 trials under your belt, but still be qualified. So I'm wondering if you've considered kind of additional experience outside of 10 trials. I think there needs to be a bigger conversation about that.
Yui Wing for the record, and thank you, Assemblymember Roth, for the questions. I agree with you. I think this is still a work in progress, and as I am a legislator, I am not a lawyer. I only play one every other year. The challenges is that we want to hear from all the stakeholders in the process, and I want to make sure that we hear from everyone. So I would love to work with you, Assemblymember Roth, to add more languages that would be inclusive of all the experiences out there, because we want to make sure that folks who have relevant experience have the opportunity to declare those experiences, as well as looking into how they can meet the qualification that is relevant, so that when they do decide to run for judge, they have the ability to do so. So I would love your guidance on this, and get more support on how to make this work for everyone. Thank you.
Assemblymember Roth, does that conclude your? Okay, thank you so much. We will move to Assemblymember Cole.
Good morning. Thank you. So my question is related to Section 4, where we talk about it's not going to affect or abrogate or affect the current term of office of any district judge. I think I understand the intent of that is that anybody who is a judge now doesn't have to be taken off the bench. But when they run for re-election, they may not qualify based on this. So I'm thinking you could maybe change the language to say not abrogate or affect any judge, any current judge as of this date instead.
Yui Wing for the record. Thank you, Assemblymember Cole, for the question. Yes, I agree with you. It is not the intent to completely clear all the benches in our state. That would be bad for our justice system. I do want to make sure that the intent is not retroactive. We are going to move from this point forward so that we can work on how to provide more training if needed, and make all of the qualification be a standard and setting the floor for Nevada. And I would love to do that. So thank you for that suggestion, and I will make sure to go back and clear the language so that we do not have the retroactive language in there. So thank you.
Thank you so much. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for joining us in Judiciary this morning. So my question is actually on a different section of the bill. I would like to look at the minutes of the commission's sessions. So in that portion of the bill, it says the commission's deliberative sessions will remain private, but the minutes must be accessible to the public. And I just read that as a little contradictory. If they're private, then when we type them up in minutes, they become public. And so can you just maybe explain how you see those two concepts working together?
Yui Wing for the record, and Assemblymember LaRue Hatch, thank you for catching that. I think this, in drafting, we probably did not read this out loud, probably only 100 times. We'd probably need to read it out loud 101 times. So I'm going to go back and ask to make some changes in this, just to make sure that the intent was to keep private information such as addresses and phone number, or those has to do with privacy issues, but the name of the a person and the deliberation content will be public. So we just need to reword that a little bit different. So thank you for catching that. Thank you.
Thank you. Our next question is from Assemblymember Gonzalez.
Thank you, Chair. Good morning. Thank you for your presentation. My question is, there is an amendment here from the Commission on Judicial Discipline, and I was curious if you accepted this amendment. Is this a friendly amendment?
Yui Wing for the record. Thank you, Assemblymember Gonzalez, for the question. I have not seen that yet, so I look forward to look at it and see how we can work together on that. So thank you.
Assemblymember Dahlia, do you still have a question? or a new one? You're good? Okay, thank you. Okay, so I believe we have answered Assemblymember Ornlicker.
So, one of the things, we have judges who might come from civil experience presiding over criminal trials and vice versa. Your bill doesn't worry about that. Are you not concerned about that possibility if you think it's important to have experience? Should it matter whether it's criminal or civil?
Yui Wing, for the record, thank you, Assemblymember Ornlichter, for the question. I think I am, again, not a lawyer and not in the trial system as much, so I depend on, expert like you and Assemblymember Roth and other member of the State Bar to help me craft this in terms of getting it to where it needs to be. So thank you for bringing that up. Again, my intention is to ensure that qualification set the standard for judicial candidate for trial judges. So if those concerns that you have, whether criminal or civil attorneys who need additional clarity, we work on getting that language in to make sure that we encompasses all members of the bar, should they wish to go for judicial races, that they have the experience to truly get the vote of confidence from the public. So I look forward to getting your support on that. Thank you.
Thank you so much. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair. Apologies, I wanted a second bite at the apple. So back to the deliberative sessions. This is not my world, and obviously I'm not in those sessions, right? And so I just wondered if you could speak a little bit to what is discussed in those sessions, what kind of information comes out, and is there anything in those sessions other than the addresses that really should remain confidential and is not something we want to get out into the public?
Yui Wing, for the record, thank you, Assemblymember LaRue Hatch, for the question. I think the deliberation content usually would decide what is going to happen to that particular conduct that is being investigated or being deliberated. And just to give you background, the 7 members of the commission as it stands is 2 sitting judges, 3 members of the State Bar, and 2 members of the public. And in current practice, those discussion on whatever the situation might be has not been available for anything. So, for example, if a sitting judge are in that particular deliberation, if the results were either no finding of wrongdoing or findings of wrongdoing, those records are not known to the public. So, therefore, when let's just say there's someone who did get fined or did get discipline on a certain action, that is not known to the public, and then they can be running for re-election without that particular case being available, and then the public would not know that they may be voting for someone who have had some disciplinary action that could adversely affect their ability to be impartial. So these are just part of that integrity and trust that we want to restore into our public, and we want to make sure that elected official of all roles, including our roles as legislator, to be something that everyone hold at the highest standards, and that goes for judicial system as well. So that is the intent, is just to make sure that it's not being kept behind closed door and folks don't know about what went on. So yeah, that is the intent. So thank you.
So just to follow up on that question a little bit, would it suffice if I'm thinking of an example of when I first moved here and I had a doctor here, and you can go online, kind of like a rate your doctor, and you get very brief information. It's like Yelp for doctors, right? And on there, it said that she had been disciplined for basically misuse of drugs. Okay, but that's all it said. And then it went on to say that she had completed the steps that the board wanted her to, and so her license was fully intact and everything. That's literally all it said. There were no minutes. It was not a transcript. It was not whatever the actual offense, the proceedings, all the details. It was just this doctor had had a drug-related offense. This doctor had completed the requirements from the board. This doctor is still fully licensed. So that, going back to the conversation with our fellow member, would that be something that would be suffice if the goal is just to say that, you don't always know that this person has been sanctioned, as opposed to all of the details, which again, could include very private, not just for the judge, but for the other members or people involved, and especially when it comes to safety and security, exposing those things. So would that be suffice?
Thank you, Chair Ewing Wing, for the record. And I agree with you. I think that is definitely the intent of where we're going with this. And if we need to clarify the language to reflect that, again, I do not want personal private information that could jeopardize anyone's security during that process, whether it's a member of that commission or, the judge in question. So, for most of us who are familiar with how to look up things like that, and, Chair, you are a lot more experience and knowledge in looking up things like that. Unfortunately, most members of our public, and especially when it comes to the election, don't have that knowledge to do that research. So having the information, as you said, comparable to that doctor situation is so helpful to everyone. So I would, again, follow your lead to ensure that that language, the final language, to make sure that we don't provide information that could harm someone in the sense of their privacy, but at the same time, as a officer of the court or an elected member for our state, the transparency in which we are held accountable for our action is important, and that would be the primary goal, and while this at the same time ensuring safety of everyone involved.
Thank you for that. Our next question is from Assemblymember Hanson.
Thank you, Chair. And it's good to see you. Appreciate the intent. I must admit, this is the one subject on a ballot when it comes to electing judges that I get a lot of calls from friends, family, constituents. And I must admit, a lot of times it's hard to know a lot of information. And so I'll reach out maybe to people that I know that are in the legal system that might have some familiarity with the judges. But if they've never run before, you're really at a loss, right? But I do have some concerns. My colleagues have brought up on Section 1, number 3, this idea of making things public. I think, and this probably, I don't know that you can answer this, but maybe those in the audience that might have this expertise, if they come up at some point in the support, opposition, or neutral position, maybe if we can have a little bit of an understanding why there was this privacy section of the deliberations being private. I'd kind of like to know the genesis of why we've kept that, so that we can understand maybe some of the things that they do need to keep private. I think would help us understand more about what would be kind of delicate to release. So not so much if you can answer it, great, but if not, maybe somebody in the audience at some point. Thank you.
Ewing Wing, for the record. Thank you, Assemblymember Hanson, for the question. So I'm solo today. I did not bring phone a friend. So I can get that answer for you with the commission itself, should anyone in the audience does not have the information. But I think the the grievances that came to me from constituents. Again, highlighting their call to action is that there have been actions in the past that were kept behind closed doors that could be damaging, or it could be helpful at the same time, so that the voters can make informed decisions on that particular candidate. So that is the intent behind it. I would definitely get that answer for you if the answer is not provided today by any member of the audience, and I'll make sure that I'll send it to the chair so that everyone can have that answer. So thank you, Assembly Member.
Thank you. Our next question is from Assemblymember Gonzalez.
Thank you, Chair. Thank you for the additional question. I appreciate the intent of this bill, and we run bills all the time that constituents bring to us, right? And so I know that the concern is being more educated and about this topic, right? But my question is there a specific example, or is there something that happened that led to this specific piece of legislation? Obviously, I don't want you to necessarily name drop anyone, but I'm just curious, is there something that the things that already are in place are not catching in regards to this specific topic? Thank you.
Ewing Wing for the record, and thank you, Assemblymember Gonzalez, for the follow-up questions. I think, like you said, due to the privacy of those members who are afraid of retaliation, they don't want to make their story public. But I think the gist of it is that there are concerns, and this is one way to address it. If there are more ways to address it, we would love to see how we can do that. Because again, this is not saying that everyone is bad. This is just saying how we can make the processes of disciplinary actions to be disclosed in a way where the intent of it is ensuring the public knows and trusts the action that we hold ourselves to the highest accountability. So I definitely want to echo their concerns that this is a way to do it. We look at how we can make it more accessible, and this is the first step. And I look forward to work with stakeholders who feel that there may be a different way to do this, because as you all know, that this legislative process, the hearing is just step one, and we're gonna go back and see how we can come together and address all the concerns so that we can all agree and move forward. So thank you.
Thank you so much. Our next question is from Assemblymember Cole.
And I really think that what you just said probably gets to what I was going to say. The letter that was submitted by one of the members of the commission has some really good information on there, and I learned something new today, that you can actually go on their website and pull down all of their hearings. They have orders, and it has findings of fact. So I think that's really good information for people. I don't know how you tell the voters to go there because it doesn't come up in a search, right? But I think there's probably some good ways for you to amend this language. Thank you.
Thank you so much. Assemblymember Moore, did you have a question? Okay, please.
Thank you, Chair, and thank you for your presentation. I do have a question about being able to access this information. Let's say I have a neighbor that maybe is curious. Where would this information be made public, and how would the members of the public be able to access this info?
You were going for the record. Thank you, Assemblymember Moore, for the question. I think, alluding to what Assemblymember Cole just said, I think the process might be available, but you have to go through layers of websites or make the requests in a very, very convoluted way, so they may not be readily available, such simple as a Google search, right? So we want to make it accessible, and if through the feedback of the commission and other folks, if the process in place is complex, we want to simplify it. So perhaps after reviewing that letter, I would be able to come back to the committee with a gold star action to make it simple. So thank you for bringing that up.
Thank you. I'm going to ask some anecdotal questions, okay? So anecdotally, we know that often there are attorneys on both sides, the prosecution or the defense, that actually it's a form of swagger not to make it to trial, right? And so they may be very experienced, years in their field, could be possibly hundreds of cases, and may have very few trials, and feel that is a badge of their performance or excellence because it's not going to trial. So how in that case, because again, it could be someone with 20 years experience, just unlimited cases in their resume and very few trials, but again, many people in the legal community feel this is actually a sign of their exemplary skills and performance. So according to this bill, this would eliminate that person from running for a judge. So could you expand on that, please?
You were waiting for the record, and thank you, Chair, for the question. I think that the original language of the bill, but I think with the amendment, the conceptual amendment that was submitted, apologies for the tardiness, it opens up a little bit more. So arbitrations is part of it, and additional languages that I think would help expand, just like what Assemblymember Roth said. The trial from start to end, yes, you are correct. There are times where it's good to just settle outside, or at times to just not make it to the actual trial itself. But the trial process, including hearings, including different part of the trials, even before it gets to the jury trial, should count as well. So that's why I'm working on this with stakeholders to ensure that we look at the entire ecosystem and not just one part of it, right? So trial experience needs to be defined a little bit more in details, and that's what I need to work on still. So with your permission, Chair, I will work on the amendment some more, as this is conceptual at this point, and with the experts, member of the bar here, and adding to your stories in terms of that experience, that again, we're not attempting to disqualifying experienced people. That is not the intent. The intent is to ensure that the right experience will be identified, so that the public know that they're not electing someone who's just walking into the role and still learning on the job. And that's the intent.
Thank you for that. And it also leads to another part of that question, and I appreciate recognizing the work that attorneys do behind the scenes, because it's just like us. We just don't show up on this dais, right? There's a lot of work, a lot of hours, things that people don't see that we actually have to do to get us to the point to get on the dais before we can actually go through a hearing on bills. And the same thing, it's not just the trial. There's a lot of work that attorneys do prior to that. So my other question about this, again, anecdotally, there's also cases where an attorney may have trial experience, but when we talk about trial experience, we have to realize that there's no specific set time to how long a trial is, right? You could go into a trial and it could be an hour and a half, it could be a year and a half, if not longer. So then how would we, to quantify it to a certain number of trials, when maybe someone has spent the last 15 years in court, but that may only equate to maybe 6 or 7 trials. And so again, how does that issue of, like a quality over quantity, again, for attorneys?
You were waiting for the record, and thank you, Chair, again for the question. And I want to speak to the proposed conceptual amendment again, that we expanded that and looking at materially participated in trials or arbitration. So that does reduces those concern that you have, and when you were talking about the length of trials, that some point it could have something that takes 3-4 years, and that could disqualify them. But we're not just specifically talking about jury trials. We can also look at bench trials, or short-term trial that could be done. Bench trials sometimes are done in one day, right? A hearing like a temporary protective order hearing, that is considered part of the trial ecosystem. So we can add that language in if it makes the committee feel more comfortable, just so that we encompasses the list of everything during the trial, outside of the jury trial as well. Because I do agree with you, Madam Chair, that the jury trial is one of the most complex and lengthiest one, and we don't want just to have the candidate just have that experience by itself, but the entire trial ecosystem as part of their experience as well.
Thank you for that. And again, we all appreciate, we've all been on the side of where amendments roll in last minute. I was on that side in your committee just yesterday. And so, where we can't have them posted and meet committee deadlines. But also, we all have been in the position, too, where we're having the hearing and we're still in the process of working on amendments as well. So we appreciate that. With that, not seeing any additional questions, I will go ahead and open it up for testimony. So we'll start here in Carson City. Again, I ask that you state your name and please spell it so that we have it correct for the record, as well as please keep your testimonies to 2 minutes. We will begin here with testimony in support of AB 141.
Good morning, Madam Chair and members of the committee. For the record, my name is Vivian Perez, Vivienperez. I'm a student at UNR majoring in political science, and I am Assemblymember Wynn's intern for the 2025 legislative session. I am here in support of AB 141. Currently, Nevada does not require trial experience for district judge candidates, yet courtroom experience is crucial for fair rulings. This bill fixes that by requiring candidates to have served as counsel in at least 10 trials or arbitrations in a Nevada district court, ensuring that they are prepared for handling trials. This bill also improves accountability by making judicial discipline minutes public while protecting our current judges. I urge your support to uphold the integrity of our courts. Thank you.
Thank you so much. Anyone else here in Carson City wishing to testify in support? Not seeing anyone? Is there anyone there in Las Vegas that would like to testify in support? Please proceed when you're ready.
Thank you. Madam Chair, members of the Assembly Judiciary Committee, thank you for the opportunity to speak today. My name is Phil Hymanson. I've been a trial lawyer in Nevada for 42 years. I'm appearing before
sir,
you as the current president.
Sir, can you spell your
Yes.
name, please? Spell your name.
It's Philip Hymanson, Hymanson. I'm the current president of the American Board of Trial Advocates. It's called BOTA. I'm the president of the Las Vegas chapter with personal experience of over 150 jury trials, 50 in criminal and 100 plus in state and federal courts. The proposed legislation requiring judges to have conducted 10 jury trials, as you can expect, I would be widely in favor of. Unfortunately, upon careful consideration.
Sir,
Yes.
is your testimony in
Yes.
support of the bill or opposition?
Neither.
Okay,
My-
then we
my
have a
testimony-
neutral, and I will call up neutral in a few moments. So if you're neither in support
apologize.
or that's fine. If you're not in support or opposition, then we have a neutral. So that will come after.
Well,
Okay, so I will call you up later for
That's fine.
neutral. Okay, thank you so much.
I I apologize for missing the procedure.
No, it's okay. I think sometimes it's, when you're in Las Vegas and we're up here, things get like a little mistranslated sometimes. So, anyone else here in Carson City anyone else there in Las Vegas for support testimony? Okay, broadcasting, will you open the lines, please?
If you would like to testify in support of Assembly Bill 141, please press star 9 now to take your place in the queue. Follow with the last 3 digits, 666. Please press star 6 to unmute your phone. You may begin.
Good morning. Thank you, Madam Chair, members of the committee. My name is Cami Dempsey, spelled K-A-M-I, Dempsey, D-E-M-P-S-E-Y. I'm representing both the Nevada Press Association and the Open Government Coalition. We support and appreciate the sponsors' efforts in bringing this bill forward. As organizations committed to transparency and ensuring public access to information, we believe this legislation strengthens those principles. We acknowledge that amendments are being proposed and look forward to reviewing them once they are available, as well as collaborating with the sponsors throughout this process. Thank you for your time.
Thank you so much. Next caller.
You may begin.
Hi, good morning. This is Jay Bloom, J-A-Y-B-L-O-O-M. I'm a resident of Nevada, and I own a number of businesses, and I've had experience on the civil side of the court. I know there was a question about examples that led to this legislation, proposed legislation. I've seen on the civil side contracts that were thrown out because once the other side says they didn't read it. I've seen judges that have appointed special masters that were former defendants to the adverse party. I've seen a number of things on the civil side that are indefensible. Most of our judges are actually very good, but the few that are bad are so impactful on the residents and the businesses. I'm not sure if anybody's aware, we actually have the National Chamber of Commerce advising businesses not to come to Nevada because of our judiciary, because a contract's not a contract. And even beyond businesses, even beyond civil, criminal family law impacts people's lives horrifically with wrong decisions. So this is important that we have qualified judges. And I don't know how anybody would come out in opposition to the judges being qualified. The first time a judge comes out should not be their first time in court. They should have some experience that they can rely on in terms of being familiar with the procedures and the policies of our judicial system. And I think the disclosure is important as well. Litigants or any participant in the judicial system is required. All of their pleadings are publicly available. We shouldn't hold the judges that preside over these citizens to a lower standard than the citizens themselves. Thank you.
Thank you so much. Next caller.
There are no other callers to testify in support at this time.
Okay, thank you. Then I will go ahead and open it up for opposition testimony, beginning here in Carson City.
Thank you, Chair. Michael Hillerby, H-I-L-L-E-R-B-Y, on behalf of the Nevada District Judges Association. Nevada has 82 district judges serving all 17 counties across 11 districts. Members of the bench come with a wide variety of experiences across hundreds of chapters of Nevada revised statutes. We are opposed to the bill, specifically the trial experience included in Section 2. You'll see in the existing language of statute the requirement that to qualify for a district judge, you need to have been a practicing lawyer for 10 years, at least 2 of which in this state. In addition to those requirements, in Chapter 3, you will find some specific education requirements of all new judges. Those for general jurisdiction must take coursework at the National Judicial College. Those in family and juvenile law will take courses before they take the bench from the National Council of Juvenile and Family Court Judges. The experience, and you've heard some good questions from Member Roth about criminal versus civil, and from the chair about the behind-the-scenes experience, because only about half of what a judge does is what you see on the bench. There's preparation, teaching new clerks about the law, doing research, and preparing for trial. There are a wide variety of areas of law where people may not get trial experience, but by any standard we would consider very experienced. Probate, transactional law, water law, land use, BLM leases, the Public Utilities Commission, labor law, where they may be appearing before the Personnel Commission in representing their clients. That experience people come to the bench. With all of that, we think the existing requirements are appropriate. And again, that caseload that people bring at the end with that 10 years of experience, we think they can make that transition successfully to that, and that those are decisions that voters get to make. There is information out there that has also been brought up from discipline to background information about the judges, and happy to have them do that. We'll be happy to answer questions. I know there are others here to speak as well, particularly the Chief Justice. Don't want to take any more of his time, but we'll be happy to answer questions if you have them. Thank you.
Thank you so much.
Good morning. I apologize for my voice, Chair Miller. This is Douglas Herndon with the Nevada Supreme Court. I'm the current Chief Justice of the Supreme Court, and I appreciate having an opportunity to be here today. It may be shocking to hear me say this, but I'm always the first person to admit that we have judges that have no business being judges. It's like any other profession. Auto mechanics, bankers, doctors, whatever it is. So I commend Assemblymember Wynn for the spirit of the bill that seeks to improve the bench. That should always be a concern, whether you're in the legal community or not. I do not believe, however, that a hard cap metric on a specific thing that an attorney does is the best way to judge qualifications for somebody to be a judge. To the Assembly member's point, I can tell you that I learn something new every day. None of us come to the bench having broad knowledge on everything that we might see. So we have to be wise and listen and try and do our best to learn what we need to learn to decide issues the best we can. It's one of the benefits of being on the Supreme Court is that you have 6 other people to rely on their wisdom. But the district courts are the same way. Judges talk to judges, and they rely on each other to help them out with things. I can tell you that during the 15 years I was on the district court bench, I had multiple attorneys try multiple cases in front of me. They may have not tried 10 in front of me, but they tried way beyond 10 across the broad spectrum of the court. And I wouldn't want them to be judges. And I had attorneys that appeared in front of me on a regular basis that never tried cases, but I thought would be wonderful judges because of their experience and their knowledge. And the 2 things that I always place the biggest import on with judges, humility and work ethic. Your willingness to know what you know and don't know, and your willingness to work hard to learn what you don't know to be the best that you can be. I think the most important metric that we could have is what's already in the statute about years of practice as an attorney. That's what gives attorneys the opportunity to develop some wisdom, to develop some knowledge, to develop some experience, to learn from other attorneys, to see what's happening in the court that can make them better qualified to become judges if and when that opportunity arises for them. And I fear that the bill, to Chair Miller's point and Assemblymember Roth's point, might actually do a detriment to us. Most civil attorneys will tell you that their job is to keep their clients out of court, right? And if they get in court, to get them out of court as quickly as they can by motion practice, by settlement, by mediation, by arbitration, whatever it is, to get them out of court, not to go to trial. What I've noticed over the last several years, and I'm noticing now as the Chief Justice over the Judicial Selection Commission, is that we have fewer and fewer qualified attorneys that want to be judges. For whatever that reason may be, and I suspect a lot of it is because of the aspect of having to close a practice and potentially run an election and lose, and then have to go back and start all over again. I understand that. But to take what I consider to be a large swath of very qualified civil attorneys out of the mix by saying there's a hard cap on what you've done as an attorney before you're eligible to be a judge, not only will you have fewer and fewer people seeking election, you'll have fewer and fewer seeking the appointment process as well. And we try and vet people as best we can through the appointment process for all these types of things that they've done as attorneys. to try and find the best possible judges that we can. And the last thing I will tell you is that in the current state that this bill is in, with this number 10 in it, we have at least one, and I believe probably 2 or 3 Supreme Court justices who would not be eligible to run for district court. They've been judges and attorneys for decades, very good judges and attorneys for decades, with very good ratings and very good reputation and extraordinary experience, but they didn't do 10 trials because they were involved in civil cases, and they may not have done 10 arbitrations either, such that I don't think the mechanic that this bill is seeking to try and achieve the spirit of it is appropriate, and for those reasons, I'm in opposition. So thank you very much for your time.
Thank you so much, Chief Justice.
Thank you. John McCormick for the record, John, last name McCormick, MCCORMICK, Assistant Court Administrator at the Supreme Court. I'm just here to back the Chief Justice up and also say that we have concerns about making the private deliberations of the Judicial Discipline Committee public, as that could impact the way they are able to do business.
Thank you so much. And I didn't get to tell you the other day, good to see you back. So, thank you. Anyone else here in Carson City?
Good morning, Chair Miller, committee members. For the record, my name is Paul Dyla, D as in David, E-Y, H-L-E. I am the General Counsel and Executive Director of the Judicial Discipline Commission. And on behalf of the Commission, I am here to oppose Sections 1 and 3 of the bill. I believe you've received my letter to Chair Miller that was submitted the other day. And since I only have 2 minutes, there's a lot that I'd like to say based upon what I've heard this morning. But I would like to focus, I'm not going to reiterate my letter, but I'd like to focus on the testimony previously. And I think there's a fundamental misunderstanding of what the Commission does. And there is no secret discipline, there's no silent discipline of the Commission. When a case goes public and formal public charges are filed, there's only 2 things that can happen. One, there's a stipulation that's negotiated between the judge and the Commission, and that stipulation is always made public. Or there's a trial on the merits, which is a public proceeding. The transcripts are public. After that hearing, the Commission, the jurors, the commissioners, it's a court, as I stated in my letter, they go into private deliberations and they make a decision. And by law, the decision is memorialized in an order, and in that order are findings of fact and conclusions of law. So that is the process. There's no case where a case goes public that the Commission doesn't act on. If it's dismissed, an order of dismissal will be filed. So I'm really not understanding much of what I heard earlier, with all due respect. Also, the decisions, it's like a jury. The commissioners are like juries. And I'm unaware of any court or organization that has private deliberations that are required to publish minutes of those deliberations. And
Sir, we're at time. If you'd like to make your final statement.
If I may, thank you.
Yes.
Thank you very much. Also, everything is on our website. 2 clicks away, you can see our decisions. 2 clicks, and there's an organization called Our Nevada Judges, a nonprofit organization. They list all the judges in the state, and you can see their discipline, if they have any, very quickly. Thank you very much for your time.
Thank you so much. Is there anyone else here in Carson City in opposition? Not seeing anyone? Is there anyone there in Las Vegas in opposition? Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 141, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you so much. Then I will open it up for testimony in neutral. Is there anyone here in Carson City that would like to testify in neutral? Not seeing anyone? Sir, would you like to come, in Las Vegas, would you like to come and testify in neutral now? And we ask that you restate your name and spell it for the record, please.
Madam Chair, members of the Judiciary Committee, Philip Hymanson, Hymanson. My only comment is as to the number that the legislature is inclined to put on for requirement for judges to qualify. BODA has, for decades, had the best trial lawyers in the country try to become part of that group. 50 years ago, you had to have 40 jury trials. And then it was 20. Then it was 15. Then it was 10. This year, it became 7. And that's because we're just not going to trial that much. If you were to make it 10, then you would grandfather in all of the current judges. However, it would be a campaign issue for every one of them because, for example, in Las Vegas, 30 plus district court judges, only 2 would qualify under that provision. And to include arbitration as part of that 10 doesn't really address the issues of what a district court judge will have to handle when they actually go into court. The rules of arbitration are much more relaxed. They won't learn motions in limine. They won't learn voir dire. They won't learn the jury system. They won't learn how to do jury instructions. There's a whole world once you get to that level that judges need. The best recommendation I could have for this committee is that the Nevada Judicial College does a great job of taking those people that get elected, and they get elected. We're one of the few states where you get elected, not selected. And you've got to put your record forward. And I can tell you that all those judges want to do the very best job. They may not have the 10 trials, they may not have 5 trials, but none of them want to be overturned by the Supreme Court. And they pay a lot of attention to learn their trade.
Sir,
So I would suggest, yes.
Oh, I was just gonna say your time's up. If you can make your final statement, please.
Yes, I would simply say that I commend the bill. I suggest the legislature that the focus for the training be at the National Judicial College and not limit and not put a number that very few of the lawyers currently could qualify for.
Okay, thank you so much.
Thank you.
I don't see anyone else there in Las Vegas. So broadcasting, will you open the lines for neutral testimony, please?
If you would like to testify in neutral for Assembly Bill 141, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in neutral at this time.
Thank you so much. Then I will welcome the bill sponsor up for any final remarks.
Thank you. Ewing Wing for the record. Thank you, Chair and members of the committees. I've learned a lot, even in the last 10 minutes, with the intention of Assembly Bill 141. It's just simply a step forward in strengthening our judicial system and promoting public trust. You know, our court does matter, and they direct impact real people's lives. I want to say that we do have strong judges across Nevada with great experience, like our Chief Justice that you just heard from. And I know that the discussions out there is that we're trying to make it a lot harder for folks to run. And I understand that, that I can share with all of you, that I can relate to that because, of course, you know, elected officials in our state are not well compensated. So attorneys with great experiences in their right mind and they're having a successful practice would never go for these positions because, you know, you're getting a fifth of the pay, and you are working a lot more hours. So I understand the complexity of this topic, and I know that even though this is a legislation as a call to action from my constituents, I did write down a lot of information from the opposition, and I will work hard to have those conversations so that we can become first in the nation. First in the nation to provide a guardrail needed to make sure that we have our judicial system with great knowledge, experience, and understanding of the seat that they're running for. And I urge your support with this process. We're not done yet. We're just on step one. And I look forward to work with all the stakeholders involved, including all the opposition, and get this to the next step. So thank you for your time this morning. Thank you again, Chair, Vice Chair, and all of the members of the Judiciary Committee.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 141. Next, I will open the hearing on Assembly Bill 302. This bill revises provisions relating to criminal justice, and was also a bill that came through our interim committee. So when you're ready, same thing, we'll ask you to state your name and spell it for the record, and then when you are ready, please proceed.
Certainly. Thank you, Chair Miller and the rest of the committee here for allowing me to appear today. For the record, my name is Michael Browett, Michael Browett. Just to be clear, I am here just as myself. That being said, I do work for the Reno Police Department, where I'm currently a lieutenant. I have 26 years of experience in law enforcement, 20 of which now is with the Reno Police Department, and almost 32 years in emergency services. For the last 3 years, I have been partnered with the best partner of my life, my facility dog, Winter, and that's what I'm here to speak a little bit about. I've been pretty deeply involved in the world of facility dogs for the past 5 years. And as I already stated, I've been partnered with Winter for 3. So Assembly Bill 302 aims to open a door that is a closed one right now for facility dogs in the state of Nevada. Essentially, there's 3 main goals of it. One is to introduce some practices that would allow their use inside of a courtroom. And the main reason that's a closed door right now is because that's a very tall order. Obviously, there's a lot of important things that occur in courtrooms, a lot of rules, and the last thing that we want is to detract from that process, and worse than that, detract from someone's rights or violate their rights through the use of a facility dog in a legal proceeding. The second part of the bill, or another part, is to really define what a facility dog is. And then the third part addresses public access. So I want to just give a brief overview. There's currently, as of February 22nd of 2025, according to Justice Facility Dogs, which is a nonprofit organization, there's 356 facility dogs in service in 41 states. And if I can briefly just explain, a facility, there are 3 kind of categories of dogs in this space. You have emotional support dogs, which are loosely defined as pets that provide someone emotional support. You have therapy dogs, which are also pets but have some additional training to interact with people in a variety of different settings. And then you have facility dogs. And facility dogs are very professionally trained dogs who are on the same par as a service animal. In Winter's case, from 8 weeks old to 2 years old, she underwent training and assessment to ensure that she can operate in environments such as a courtroom or other highly professional environments without creating a disturbance or detracting from the processes that occur in those buildings, the same as a service dog would be expected to do. That takes a lot of work, and it is the right tool for the job. Facility dogs have been in use for over 20 years now, really getting their start in the state of Washington. This bill was the original draft is crafted to try to reflect some of the best practices of other states that do have existing laws, including Idaho, Washington, California. And I understand there is already some need for amending some of the language in Section 1 because the intent is not to take away a judge's ability to control their courtroom and what occurs in that courtroom. That the language that exists in there came from the state of Idaho, which contains the word shall. There is other language in Washington's that, it spells out a different process, and then you can get all the way down to states like California, where the use of a facility dog is decided on a case-by-case basis in a proceeding based on petitions from whichever side would like to use the said dog, and the judges can make decisions from there. So I'm very open to, obviously I'm not a judge, certainly not a lawyer, and so I'm very open to amendments that will allow judges to retain control of their courtroom, but while laying some groundwork and perhaps framework to open up the door for the use of these dogs in proceedings within the state of Nevada. The second thing, I already touched on it a little bit, is that specific definition. The most important thing is that a dog like this should come from a Assistance Dog International accredited service dog training organizations. Right now, or similar accrediting organization. Right now, Assistance Dogs International is really the player that certifies providers of service dogs. They have specific definitions of what these dogs are, and they have very extensive requirements that these dogs have to achieve in order to work in this setting. Another thing is that these dogs are partnered with someone who works as a professional in the criminal justice system. Thereby, we do not want someone, you'd be very unlikely to go out and just as a citizen get a facility dog, because most places that provide them wouldn't provide them to someone who's not a professional in the given space that the facility dog is going to work, because they're also used in other settings such as hospitals and schools. It needs, to meet that definition so that it's correctly certified, the right tool for the job, as well as partnered with someone who understands and has involvement in the criminal justice process. The third thing, the public access. This I'm also welcome to amend. The state of Washington's language actually is very good, because the intent here is to open the door to public access for these dogs to work in a setting where they'll be. Courtrooms, other police stations, stuff like that. There's absolutely no intent, nor would I expect any facility dog handler to take their dog to Winco to go grocery shopping on their day off. The language does need to be specific in that public access for a dog like this should only be granted in the places it will work when the dog is actually working, meaning connected or coupled with a client and providing services. Of course, the other exception would be any place that gives permission for the dog to be present, kind of like, Reno Police Department, City of Reno. They welcome winter in, so we have permission to be there, and that's always an exception. Just briefly, some other concerns. I've already submitted some language because in the bill you see the words emotional support, to provide a victim with emotional support. I've already submitted an amendment to change that, because these dogs provide specific tasks. It's far much more than emotional support. Dogs like Winter in fact has over 40 trained commands. In a courtroom setting, having her do a hour to 2 hour down stay and being silent, with the only giveaway sometimes being a snore or a puppy dream. That's a huge ask of a dog, but that's a trained task. That most dogs could not achieve that. Certainly not the dogs that fall into the emotional support category. So I've already submitted that. Fiscally, really there's no concerns. There's nothing in here that should be construed that this will be a requirement for any jurisdiction to have or provide a facility dog. There's a lot of language language in there that addresses this would only be if one is available. It's not a requirement, so there's no intent to force jurisdictions to go out and start these programs or start or purchase them, have them available. With that said, this is a widely supported program across a lot of states, and it's not very expensive. You are simply, at the end of the day, dealing with a dog. They need some basic veterinary care, food, and things like that. So there's lots of different funding mechanisms available, whether it be grants, private donations, et cetera, for jurisdictions who are interested in launching a program. The fiscal impacts are pretty minimal. I've heard insurance come up. I can't speak for every service dog organization that provides facility dogs, but for instance, with Winter and Canine Companions, they actually retain ownership of her for her working life, and they maintain a $1 million liability insurance policy on her. That is very similar with a lot of the larger organizations. For those that don't, there are certainly insurance policies available at a relatively low cost to organizations if they got one from an organization that doesn't cover the dog for its working life. I believe the last thing I've heard is allergies. That's always a concern. We obviously, when I'm working with Winter, I do make sure up front that there's no allergies. However, a lot of research has dictated that a lot of times it's not the dog that people are allergic to, it's stuff on the dog that they're allergic to and reacting to. And I would also draw attention to the fact that we do have service dogs crawling all over the United States. They could come into a courtroom today under the ADA Act, and you couldn't whip out an excuse about allergies to exclude them from that courtroom. So I'm not trying to make light of it, but it's something that does come up often, but in practice, it doesn't come up. I've had a handful of people who have refused interaction with Winter because they're allergic, and that's fine. To say that that's a reason to unilaterally exclude these types of dogs from that setting is not really supported by evidence. The last thing I'll get into is just, you don't really know it till you see these dogs work, the incredible impact that they have. I just want to briefly share just this past week, Monday, I responded to a call for service where a mom was having a mental health crisis, which necessitated her 11-year-old daughter to call the police. Her 9-year-old daughter was also present. We showed up. I won't get into the details of the call, but needless to say, we showed up to two very upset children, and understandably so. An aunt arrived on scene. Children were still very upset. I arrived on scene, asked them if they wanted to meet Winter. They interacted with her for a little bit, and then the 9-year-old said, "Well, at least I don't have to puke anymore." And what that demonstrates to me is, A, the innocence of a 9-year-old statement. I love that. But two, what's actually going on there is that interaction lowered that child's cortisol levels. It increased her dopamine levels. It brought her back down to a normal state of being instead of that fight or flight mode. And it may not seem like a big deal, but the quicker we can reduce those types of anxieties, the better the outcomes are for people as they navigate the criminal justice system. Just another example, in Washoe County, we had a victim of some child abuse crimes. She wouldn't talk to the deputy district attorney at all to discuss the case as they approached trial. We brought Winter in, met with her, did a courtroom tour, and she got to sit with Winter for a minute in the stand, and the attorney rightfully addressed what's already in the law that witnesses can have an advocate up there with them. And she said, "I want Winter." We had to say no, obviously, because there's just not a good legal standing for that right now. But then the most amazing thing was the deputy district attorney asked if he could talk to her some about the case, and she and Winter and the attorney went into a room and spoke for over an hour, whereas before she wouldn't even acknowledge the attorney's existence. So I'll summarize by saying, obviously, I understand this bill will need some revisions. I certainly do want to work with the judges and the experts in that area to come up with some language that lets them run their courtroom, but also lays some groundwork to make this a possibility in the state of Nevada. This has been incredibly successful in other states. If you talk to district attorneys' offices or judges where these dogs are present and work, many of them will tell you that they wouldn't think of doing a serious trial, involving a child without a facility dog, because it does enhance the process so much because the child's calm, therefore the proceeding's smoother, and things go better and the justice system rolls more smoothly. But lastly, I just want to kind of quote one of our detectives, Michael Geider. He was one of our sex crimes detectives. And right after Winter arrived, he made the observation that regardless of the outcome of a criminal case, if the presence of a tool like this can make the outcome for that victim's life better long term, then it's worth it. And I think we owe it to the citizens of the state of Nevada to try to come together to find agreeable language that will allow us to put a practice like this into place, get the ball rolling, and just lay that foundation so that the right tool can do amazing things to assist our victims. Thank you.
Thank you so much. First, I appreciate you did mention that you'll be amending just to tighten up that language, that it's specifically to the courtroom and certain hearings and proceedings, and not WinCo or just any public access.
Yes,
point.
I can certainly, I have the Washington law with me, and they very, as lawyers are capable of doing, draw out all the possible places in words that, you know, this dog should reasonably be while performing its duties, the dog and the handler. So, yeah, there's some language we can take a look at to maybe model, to limit that public access, because there's certainly no need for these dogs to have public access, the same as a service dog. In fact, I would be against that. It detracts from, you know, the service dogs that are out there doing their jobs.
Thank you so much, and I appreciate your presentation, because we know that the relief that animals can give, I mean, we've seen them be very successful in nursing homes and prisons, and, you know, it's not just kids, it's not just courtrooms, but really that connection that we have. So I appreciate that. We'll begin with questions. The first one from Assembly Member LaRue Hatch.
Thank you, Chair. Thank you so much for bringing this. I think I have the most important question of the day, which is, where is Winter?
So that's a subject of debate. I did check, you know, I did bring her to the interim hearing, but I thought best for her to stay home right now. I don't want to ruffle too many feathers, but so she's at home, but I am more than welcome to get with anybody, anytime really, because I can't stress enough that these are not ordinary dogs, and you really, I could show videos, I could do talk till I'm blue in the face. Until you meet them and you actually experience their demeanor, you truly cannot understand how amazing these dogs are. I mean, referencing back to that situation the other night, we're in a parking lot probably with, you know, 15 police cars, and we're sitting on the pavement, and she's on her back letting them rub her belly. That's not natural for most dogs. So you really have to experience that to understand how highly trained and capable these dogs are. Thank you, though, for the question.
Thank you so much. Our next question is from Assembly Member Roth. Yes, we've met Winter, yes. And we have a number of dogs that are all throughout the building. And we used to have Assembly Member Gonzalez's dog, Zero, which may not have been as trained, but now he is. Thank you, thank you. So those of us who remember Zero. But with that, our next question will be from Assembly Member Roth.
Thank you so much, Chair. I also have an untrained dog that I love very much. And that kind of gets at the heart of my question. I think, you know, all of us sitting here, the thought of having a dog in the courtroom, and it makes absolute sense to me to have them in the courthouse. But I'm going to be honest, if I was sitting on a jury and I saw a dog at the witness stand, I would convict that person so quickly. So are there barriers, are there guardrails within this to kind of address the issue of a fair trial? And then are we seeing any litigation about that in other states that have already implemented this?
Yes, and thank you for that question, because that was actually some of points I wanted to touch on. First of all, in the courtroom setting, a lot of states prescribe, and certainly as best practices within our space, the dog, it shouldn't really be known that the dog is there, meaning that the dog shouldn't be visible. They should be behind the box, perhaps at the witness's feet, and every effort should be made to do that. Now, most jurisdictions do provide jury instructions that there may or may not be a dog present in the courtroom, and that the presence of that dog should not be weighted one way or the other. There have been numerous legal challenges, many of which have been in the Ninth Circuit, addressing the bias that the presence of a dog like this could provide, and none of them have been successful. It's been found that a fair trial can absolutely occur with these animals present in the room. So through the combination of best practices, of not making it, super obvious that the dog is there, combined with jury instructions, combined with the support of case law in numerous states and including the Ninth Circuit of the United States. A lot of challenges have been brought and litigated, and the practice continues, I guess, is my non-lawyer answer. Thanks.
Would you like a follow-up, Assembly Member? Okay. You're welcome. And I just wanted to, it was just pointed out, it is in the bill, the right of the defendant. So maybe if you could, has there ever been an example in your experience where a defendant may feel that there was bias or something because of?
Yeah, I can't quote specific cases on the spot, but I do know that the way that's been handled is sometimes, I don't know the technical term for it, but sometimes there has been a specific hearing within a trial to address that very issue. And then other times on appeal, that has been brought up as an issue. And again, there isn't a case that I'm aware of where the finding has been that it did bias the case and that the trial has been, voided or thrown out or finding, I guess.
Thank you so much.
Thank you.
Our next question is from Assembly Member Hardy.
Thank you, Chair, and thank you for being here. I'll admit, I love animals, and so I think this is a great bill, especially, as it relates to children and vulnerable people. As you mentioned, the effect that just having a dog there can calm them and help them speak when otherwise they wouldn't. So my question is, would this be the facility? You mentioned they wouldn't be like, you're kind of trying to figure out, would the facility have to provide the dog, or could it be that, say, the child, their counsel could request a facility dog be there? So would it have to be provided by the court, the courthouse, or could it be requested and have the facility dog there, by the child's counsel or whoever?
Yes, thank you for that question. And again, nothing in this would suggest that any entity be required to have a facility dog. In the criminal justice system, you do see organizations that onboard these types of dogs, police departments, district attorney's offices, oftentimes through their victim advocates, child advocacy centers, other nonprofits and communities that work in this space a lot with children. In an ideal world, yeah, they'd be everywhere. But in practice, most of the time, it is a request. I can certainly tell you in Washoe, where I work, I get requests from other jurisdictions at various stages of things, all the way from time of call, clear through to pretrial interviews, interviews themselves, criminal interviews, investigative interviews. And so we try to do the best we can to accommodate those requests. So there probably are courthouses out there with their own facility dogs. However, it's usually some other adjunct of the criminal justice system that has them, and they just come in and provide that service at that time through agreement. And there's been times where me personally, I've had conflicts. I couldn't do it, unfortunately. So but there is the state of Alabama is probably one of the most coordinated. They have done a great job, and they have a statewide system of dogs now that are with all different organizations, but they have a network where if one is needed, there's phone numbers to call, and pretty much anywhere in the state of Alabama, you can get a facility dog when you need one.
Thank you, Chair. So that I'll just throw out the next two questions. How many, you might have mentioned this, how many facility dogs do we have in Nevada, if you know? And then would this be available, say, you don't necessarily are requesting the dog in the courtroom, but what if if a judge meets with the child in chambers, or, if there's a deposition or some other type of proceeding, they could be it's not just specific to courtrooms. Is that correct?
Correct, absolutely. The dogs can be used at any stage. Like, since I'm based with the police department, there's opportunity there to have them at the time of a call for service. And in some instances, Windsor has traveled through the entire process from time of call to interviews with detectives to pretrial hearings with attorneys to I haven't met with a victim or witness with a judge yet. But that would certainly be a possibility. The reason the courtroom is so particular is obviously because of the stakes in a courtroom, and as Assemblymember Roth pointed out, the potential for that unfair bias of the presence of a dog. There's certainly ways, and many states have proven to navigate that, but really the rest of it doesn't have quite the legal risk that the presence in the courtroom does. So I'm not aware of any states who have really codified those other uses in law. It's really that courtroom, inside a courtroom, that necessitates usually some rules, policies, procedures. The rest of it is out of public sight typically, so it's not likely to bias a jury. Thank you.
Thank you so much. Assemblymember Gonzalez, do you still have your question?
Thank you so much, and thank you so much for the presentation, and shout out to my dog Zero, who has had training now. Thank you very much.
I just want to add the standard of not knowing the dog was there.
But I appreciate that folks remember him. He's very memorable. But my question is, and I think I heard you say that defendants can have dogs. So can anyone request a dog? What if both parties request a dog? What if more than one person requests a dog? How does that? I don't know if you have seen that in any cases across the U.S. Thank you.
Yeah, so that does come up. Typically, as handlers, if a defendant requests a dog, there's absolutely no reason, that they shouldn't. Now, here today, we're discussing children and vulnerable witnesses. There needs to be some limitation. There needs to be a reason for this dog to be present, and that reason needs to be enough that it's probably going to enhance the judicial process. So no different than, I wouldn't expect a normally functioning, 30-year-old adult to request a facility dog or be granted it. Like, they should be able to get through that. That's something to explore, but it's not very common practice. As far as competing requests, I haven't had that happen. However, I know other handlers who have. And typically there's a relationship established prior to a trial with a facility dog. You would almost never have a facility dog meet with a victim for the first time the day of trial. And so most handlers and organizations, if there's already a relationship established, perhaps and a defendant wants one and is entitled under whatever rules dictate whether someone should or shouldn't have a facility dog in a courtroom, then you would have to seek out another facility dog. You wouldn't ever want the same facility dog servicing, a victim and then hopping over and doing the same for the defendant in the same case, for obvious reasons, because that will detract from the usefulness of that dog in the victim's mind, because now that dog is, for lack of better terms, even though the dog is obviously completely unbiased, the dog in the victim's mind could be tainted now. So best practice is to always keep that separate. I suppose if there was a competing interest and only one dog available, a judge or someone would have to make a decision of either who gets or no one gets, I guess.
Thank you for that very thorough answer. I appreciate that. So are we saying that, well, if I understand your response correctly, anybody can request a dog, but then also your presentation was on children and vulnerable folks. So I'm curious, are you wanting to include parameters of who can request the dog?
So the bill as written does do that. It heavily limits it to children and then also vulnerable witnesses. I think it defines that. I know there's numerous sections of NRS that refer to vulnerable adults, vulnerable. There's many different state definitions that already exist that we could draw from. But really, what you're looking at is if someone does have a disability that creates great anxiety in them, and obviously testifying on a stand would be a trigger for that type of thing. That may be a situation where a dog like this could help. I think there does need to be some bumper rails. I certainly don't envision, nor do I think it would be reasonable to have a dog in a courtroom at every single trial. And that's certainly not the intent.
Thank you so much. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you for being here, and a shout out to Winter.
Thank you.
So other states are doing this, so we have some precedents, but I noticed, well, let me clarify. Other states are doing this. This bill says in Section 1, number 2, if a court authorizes. So the court still would have discretion whether that judge wanted to allow this, but another courtroom could. Am I understanding that right?
Yes, and as I mentioned, the language may need some cleanup. Washington's law actually does a great job of the first paragraph in theirs specifically states that nothing in there is meant to take away from the discretion of the judges to make decisions regarding how their courtroom is run. So it's flirted with in here. I certainly understand the concerns, especially at the constitutional level with regard to like separation of power and stuff. I'm hopeful we can, I can meet with people who have those concerns to come up with some language that doesn't interfere with that. Many other states have, and I'm hopeful we can close that gap. There are spatterings of that discretion still existing here, but I'd like to make judges comfortable that they absolutely have that discretion.
And if I could
should.
follow up? Thank you. Thank you, Chair. Thank you for that. And that makes me comfortable, because the idea that, if in a way it's almost like a little pilot program. Some judges could opt to use it, see how it goes. Other judges might wait to see how it plays out. Also in Section 1.1, only in criminal proceedings. This isn't going to creep over to civil court. It's only for criminal, dealing with vulnerable witnesses, correct?
I believe down in, what would it be, Section 1, Paragraph 3C, it also includes the proceedings relating to abuse or neglect.
Right.
But yes, other than that,
okay.
Yeah, I wouldn't expect much work in the other areas. And if I may, Chair, someone asked earlier I believe someone asked how many dogs were in the state. To my knowledge, at least as far as a canine companion's dog goes, it's just me and Winter. There may be others that I'm not aware of. There are other facility dogs working in other areas, such as hospitals and schools within our state, but I'm not aware of any others now. And Assembly Member Hanson, if I can also comment on the pilot project kind of nature of it. I totally agree with that. I think the main intent is to make sure that we define the right tool so that we don't end up with people trying to use the wrong tool in the courtroom and ended up with case law that would ban essentially dogs from a courtroom. And the wrong tools are very likely to lead to rulings like that. So again, really the access, the what is a facility dog, and then the implementation, should certainly be left up to the courts and the professionals who oversee that process, just ensuring that if they're going to consider it, that they're considering the use of the correct tool, and that tool has some leniency under the law to enter those spaces and do their job.
Thank you. And I just want to reiterate, because I know not everyone had the opportunity to participate in the interim committee where this came forward. And it really was the intention to make it permissible and not prescribable, but permissible for those courts that wanted to, allow this and to have those parameters. And that's why sometimes we don't make things so prescriptive, but that it would support those who wanted to allow it. Our next question is from Assembly Member Nadeem.
Thank you, Madam Chair.
That was my question actually, that if we have one dog in the whole state of Nevada, then we will be requiring or needing a program to have, to a program how we can train the dogs and have more facility dogs?
So there's a number of organizations that serve the state of Nevada to provide these dogs already that are out there, and so we wouldn't necessarily need to stand up, certainly not through government, any type of organization that trains these dogs. Entities would, if they wanted to start a program, would certainly reach out to those already existing service dog training organizations that have that Assistance Dogs International accreditation, and go through, everyone has a different process, and go through their process and hopefully be paired with a dog and be able to put it into a working environment within their setting, which falls within the criminal justice system.
Thank you.
Thank you. And just to clarify, do we know how many states have actually passed legislation like this? Because I know sometimes it may be happening because it's happening. It doesn't mean that actual legislation's been passed. It just means that it's the process has occurred. So do you know how many states have passed similar?
I don't know exactly. I can tell you my focus has mainly been on the western states and those that fall under the Ninth Circuit, mainly because that's going to be what's pertinent to us. There are definitely other states across the nation that do have laws, and I can certainly get that number and perhaps do some more digging to get those laws as well. When you read them, they're all very, very similar. As I stated at the outset, Idaho's is the most succinct and just says, we're going to allow it. I think it needs, I don't disagree, it needs to say a little bit more than that.
Sure. Thank you so much for that. With that, I don't see any additional questions, so I will go ahead and open it up for testimony in support of Assembly Bill 302, starting here in Carson City first.
Good morning, Chair Miller and members of the committee. My name is Rebecca Goff. For the record, R-E-B-E-C-C-A, G as in girl, O, F as in Frank, F as in Frank, and I'm the Nevada State Director for Humane World for Animals, formerly known as the Humane Society of the United States. We're here today in support of AB 302. The animal-human bond is well documented to bring many mental and physical, even physical health benefits. In this case, by allowing these specially trained facility dogs in court, we believe that this bill will help bring significant comfort to victims, especially children, during a time of extreme stress. It can help a victim's confidence and give them the feeling of security and that they have a comforting companion in their corner. We thank the committee for bringing this bill forward and urge you to vote in support. Thank you.
Thank you. Is there anyone else here in Carson City that would like to testify in support? I don't believe there's anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in support to Assembly Bill 302, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Assembly Bill 302, please press star 9 now. Chair, there are no callers wishing to testify in support at this time.
Thank you. Then I will open it up for anyone in opposition testimony.
Good morning, Chair Miller and members of the Assembly Judiciary. Paloma Guerrero, P-A-L-O-M-A, G-U-E-R-E-R-O. I do want to apologize to Lieutenant Browett. We didn't get a chance to talk before the hearing. I couldn't figure out who was going to present the bill, but we hope to work together on these concerns. I'm not proud of this opposition. I want nothing more than to walk into a courtroom and see dogs there, but here we are. We always have to balance the rights of victims and also the rights of the accused, and people have a right to have a fair trial. Everyone is presumed innocent until proven guilty. And what we want the jury to do is have a dispassionate review of the evidence. We want them to weigh everything and assess witnesses' credibility without any sort of outside influence. The presence of a dog is likely to create biases in jurors because there are well-defined psychological reactions for people when they see dogs or they see people with dogs. And this issue has been studied. Texas A&M University looked specifically at how judges view the presence of a dog during testimony, and judges themselves expressed a worry of how the presence of a dog could increase sympathy for a victim. A researcher designed an experiment to see how the use of facility dogs would affect juries, and what the experiment showed is that the presence of a dog makes the jury more likely to rule guilty. The bill as written is extremely broad and susceptible to litigation. It allows any minor in any criminal proceeding to have access to a facility dog for any reason. What other states have that this bill doesn't is a sort of balancing test, a requirement that a substantial need for the facility dog, that there needs to be some sort of finding that having this facility dog is going to help the witness in their testimony to even try to balance out the prejudice to the accused. And Lieutenant Browett is right, there have been cases that have upheld the use of facility dogs, but the difference in those cases is that they'll require proof of why that facility dog is a compelling necessity. And those cases all acknowledge that there is prejudice to the accused. And there has, I did find one case in New York that was overturned based on the use of facility dogs. And again, looking forward to discussing these concerns with Lieutenant Browett. Thank you.
Good morning, Angela Knott from the Washoe County Public Defender's Office, Angela Knott. We are not asking you to vote against dogs, okay? We love dogs, but it's that love and the distraction that's a problem. And we oppose AB 302 in the trial setting, because at the end of the trial, it's the reliability of the verdict that is important. We actually like the idea of having a dog in a courtroom with a child versus like a human person who stands next to the child, right? They can send nonverbal cues to a jury, maybe not intentionally, and a dog wouldn't do that. But unfortunately, a dog is too distracting, and you will know that a dog is in the courtroom because you would have to address it during jury selection. You would have to ask the question, who here has a fear of dogs? Who here is allergic to dogs? Who here would have an issue if a dog was in the courtroom? Who would more likely like the testimony of a child because she had a dog with them? These are all questions that will get brought out in the jury selection before we even get started on the actual case itself. And it's also these types of issues, like a child testifying, where negotiations in a case are so important. Nobody wants to put a child on the stand because it is scary. But when we are forced to go to trial, it's the defendant's due process rights that must be protected. Thanks.
Good morning. Chair, members of the Judiciary Committee. My name is Keith Lee, Keithle, and I'm here today on behalf of the Nevada Judges of Limited Jurisdiction, who are the Justices of the Peace and the municipal judges in our state. And Madam Chair, before I begin my formal testimony, I must make clear that I love dogs as well. I've had dogs virtually all of my life, from ranch dogs to pets to my support dog during the bar exam until still to today. And I must also confess that the first question I asked Mr. Browett this morning when I introduced myself and met him was, what breed was his support dog? And he indicated it was a yellow lab, and I indicated I love labs, but I must confess I lean towards the chocolate variety. But nonetheless, we are here in opposition to Section 1, subsections 1 and 2 of the bill as it's written, that mandate that the court must consider the use of facility support dogs in this situation. We believe that clearly is a violation of the Separation of Powers Clause of the Nevada Constitution, which you can find at Section 3, or Article 3 of Section 1 of the Nevada Constitution. And the purpose of this clause is to prevent one branch of government from encroaching upon the powers of another branch of government. And it recognizes that there are, of course, three branches of government: the legislative, the executive, and the judiciary. And I want to make sure you understand from our perspective that it's been long recognized in Nevada law that constitutionally this legislative body may establish the substantive rights of individuals. And you do that, and you've done that. I give as an example NRS chapters 193 to 217, where you establish substantive rights of individuals to appear in court. But procedural matters of the court's conduct in the courtroom, including the manner and method of testifying, control of its employees, managing court dockets, processing paperwork.
Sir,
Yes,
your time is up,
I'm
so
sorry.
can you make your
Thank
final
you.
statement?
Yes. Procedurally, matters in the courtroom are up solely to the judiciary. And we oppose section 1, subsections 2 and 3 of the bill, or 1 and 2 of the bill, pardon me. I've already discussed our concerns with Mr. Browett, and he recognizes them, and we're willing to work with him, and we have some really great ideas to go forward with the use of facility dogs in proceedings. Thank you.
Good morning, Chair and members of the committee. Again, John McCormick, John, last name McCormick, MCCORMICK, Assistant Court Administrator at the Administrative Office of the Courts. I am just here to indicate that our concern is regarding the use of shall in sections 1 and 2, and we look forward to working with Lieutenant to get a better bill. Thank you.
Good morning, Andres Moses, ANDRES, MOSES, on behalf of the 8th Judicial District Court in Clark County, here to echo the concerns that have already been stated by Mr. Lee and Mr. McCormick. We appreciate the intent of the bill, and we thank the sponsor for having discussions with us, and we look forward to continue working with him. Our opposition is to Section 1, as we do feel that the decisions about the policies and regulations of courtrooms are best left to the court and the judges to decide. And in Clark County, we have had this issue come up in our family courts, and it is something that we've researched and analyzed and have talked about policies, so it's something that we'll continue to work on, and we are looking forward to working with the sponsor. Thank you.
Good morning, Chair and members of the committee. My name is Jeff Rogan, JEFFROGAN, and I'm here testifying in opposition only because of the rules of the committee. On behalf of our Department of Family Services, we fully support the idea of having these types of facility dogs available in criminal proceedings and child welfare proceedings as indicated in the bill. For those of us that have been in a situation where we've had child witnesses and we've had to ask them to testify, often that's not really something that we'd like to do. But sometimes we have to, based upon the nature of the proceedings. We don't have a choice. We have to proceed to a hearing. We have to proceed to a trial. And any way that we can provide comfort to a child that is in that situation would be beneficial. And having facility dogs available for that purpose is a great idea. Our only reason that we're here in opposition today has been mentioned, and that's with Section 2. We just need to further refine the issue of where these dogs may be admitted, and I'll work with the sponsor on that. Thank you very much.
Thank you so much. Anyone else wishing to provide opposition testimony? Not seeing anyone else here in Carson City, and there's not anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 302, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony. Anyone wishing to make neutral testimony here in Carson City?
Thank you, Chair Miller, committee members, Ms. T. Grimmer, GRIMMER, for the record, representing the Nevada Resort Association, and I want to express my appreciation, Chair, for taking the time to meet with me last night to get clarification. And then, of course, the proponent also put the clarification on the record today that the definitions of public accommodation will be amended. Public accommodation is a very broad standard in the state of Nevada, so I appreciate that amendment. I really think I should have come up in opposition because Winter is not here. But I absolutely love this bill, actually, and I can say from, like everybody else who's got dogs, that my dog is very much a part of my stress relief and mental health. So I appreciate this bill a great deal. Thank you.
Thank you so much. Is there anyone else in neutral here in Carson? Not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to testify in neutral for Assembly Bill 302, please press star 9 now to take your place in the queue. You are unmuted and may begin.
Good morning, Chair Member Brittany Miller and the rest of the committee. Could you guys hear me okay? I apologize. I'm breathy. I didn't know I was going to testify.
Yes, we can hear
Could you
you.
guys hear me okay?
And I just
Thank
wanted
you.
to make sure, we're in neutral right now. Are you testifying?
Yes.
You're in neutral?
Yes, because I haven't read the bill. It's not accessible fully, 100%, and I'm going to work with LTV accessibility to see if we have any amendment to suggest, and I'll submit it before tomorrow.
Okay.
This is Dora Martinez, Madam Chair. As you know, I do have a service dog who is legit, can't read Braille, brings me to the men's bathroom, but he's still my service dog. We're just concerned that, because as a disabled person who has a service dog, we have been harassed because people say, oh, we are allowed to pet the dog, and they're not. Different degrees and level of ADA, as I'm sure the lieutenant has mentioned. But I just want to make sure that this facility, I haven't read the laws, like I said, but make sure that the facility dogs are only for the court, and they are legit facility dogs. Like right now, we just came across a person that had a service dog. It had a vest, and it says dog in training, and it was a pit bull. So I just want to make sure that the breed is lab or whatever legit breed, and that they don't abuse the system. But we will read it, the laws, and see if we have any amendments, because I am part of the Guide Dog User International, which is over 100,000 members that use a service dog. And I appreciate you, Miller. My daughter loves you, and she thinks you're awesome. Thank you so much. Have a great day.
Thank you so much. Next caller.
Chair, there are no other callers to testify in neutral at this time.
Thank you. Then I will go ahead and close testimony and welcome the lieutenant back up for any final remarks.
Thank you, Chair Miller. Again, for the record, Michael Browett. Just a couple things to address, and I want to stress, while I'm certainly not in opposition to amendments that remove that shall language and make it more amenable, as the Legislative Council Digest in the bill points out, NRS 178-571 does already require courts to grant certain accommodations to certain minor witnesses. So I'm not sure, again, not a lawyer, how that balances currently with the separation clause, but obviously the legislature has taken action in the past to direct some action of the courts. I say that obviously with a huge caution of I'm not trying to stick to my guns on that shell language. I think we can find some common ground. I know the question was asked earlier. According to the American Bar Association, there's 16 states currently with laws regarding facility dogs, and their language is something to the effect of laws that allow specifically permitted and authorized dogs to act in this capacity. One thing that I didn't mention earlier is that there, between 2018 and 2021, a number of organizations published documents in support of the use of facility dogs in courtroom, to include the American Bar Association, the National District Attorneys Association, and the Association of Prosecuting Attorneys. And I believe there is also one out there from a defense attorney organization that does also support the use of them, so I will get my hands on those. But again, not a new concept. A lot of the questions and concerns that have come up here are absolutely legitimate, but have been vetted in a lot of other jurisdictions, and solutions have been found. The last comment I want to make in regards to the last neutral caller there, one of the things about being a facility dog handler has been exposure to the service dog community, and unfortunately there is a huge amount of service dog fraud out there, where people do just slap a vest on any old dog and call it their service dog. I understand that, and again, with the limited language, with public access, the hotel concerns, I think that's a necessary step. And I also believe that reinforces why we need to do a good job of defining exactly what these dogs are, and the training that they need, because you don't want the wrong dog coming into a setting like this that, heaven forbid, ends up biting a child or something like that, because that's unacceptable. And so we need to know that we're using tools that have been so seriously vetted by professionals that we know that there's virtually no risk of that happening. I can tell you with Winter, I would leave her alone in a room for a week with a newborn. She's been stepped on, kicked, everything else, and always reacts with just a look up to me of like, hey. So it really does take the right tool, and not using the right tool can have some catastrophic consequences. So all the more reason to define it for all the stakeholders involved. I appreciate everybody's time here today, and I look forward to working with everybody to find some more suitable language to bring this forward.
Thank you so much, and thank you so much for presenting today. With that, I will go ahead and close the bill hearing for Assembly Bill 302. That concludes our agenda for today, so I will go ahead. Except for public comment. We will conclude after public comment. So with that, is there anyone here in Carson City that would like to make public comment? Not seeing anyone. There's not anyone in Las Vegas. Broadcasting, will you open the lines, please?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now. Chair, there are no callers choosing to provide public comment at this time.
Thank you so much. Well, then now I will adjourn this meeting and see you all tomorrow morning at 8 a.m.